A Massachusetts trooper dove headfirst into the open driver's side window of a vehicle during a traffic stop, and for some reason, the only thing the media seems to care about is peddling their political agenda and demonizing the person being stopped. Not one story has emerged that focused on why in the hell a police officer would do such a thing. That is, until now. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. I guess the Massachusetts State Police didn't get quite enough negative attention from the media during the Michael Proctor debacle and the seemingly statewide corruption exhibited in the malicious prosecution not once but twice of Karen Reed. Now, they have their troopers diving in car windows, and just when I thought that the media might see this case for what seems obvious to me that it is, which is an overreach and reckless conduct on the part of another Massachusetts trooper, it's somehow not being covered even remotely close to the way it should be. Have the brass at the Massachusetts State Police infiltrated the local media and manipulated their way to having this story being covered in a way that diverts the attention of the public away from what actually matters? Maybe. I don't know. But for whatever reason, every major news outlet in Boston buried the lead on this case and managed to turn this story into some stupid discussion on modified machine guns or background checks for city employees. What? I mean, if we're going to go there, how about a closer look at the psychological profile of the cadets for the Massachusetts State Police? The conversation about background checks for city employees and modified machine guns are either completely bogus, irrelevant, or at best, something we wouldn't even know about in the absence of this trooper doing something that is just flat out reckless. But just for context, let's check out the story from WCVB Channel 5 out of Boston, and then we'll come back and talk about some of the things they've willfully ignored in the course of their coverage.
Hold on. Why? Yo. No.
Wow, that is breaking news. It is video you're going to only see on 5 as this traffic stop turns violent. The state trooper ending up going right through that window, as you see. 5 investigates broke the story at 5 p.m., revealing that a Boston City worker is now behind bars after that wild encounter.
Let's get to our Brittany Johnson. She's been digging into how all of this unfolded. Brittany?
Well, Ed and Maria, this is just the latest case of a city employee landing in trouble with the law in recent months. And in this case, that worker is being held on 5 felonies after a confrontation with both the suspect and the trooper being tased.
What's up, man? How you doing? Good. Give you a license registration?
It starts as a routine traffic stop in South Boston. A state police trooper spotting a car with window tint that appears darker than allowed by law. It all unfolded here on Old Colony Avenue, just past a traffic rotary.
I just got out of work.
What do you do? I can't see the ad.
Oh, City of Boston.
The driver, Nasiru Ibrahim, on the city payroll, working in the property management department.
No, you're good. Just relax.
No, I know.
The trooper writing in his report that because Ibrahim's demeanor was nervous and he admitted to prior firearms charges, the trooper asked to inspect a backpack on the passenger side floorboard.
Now, I just want to pause this here briefly and note what was just reported. This trooper wrote in his report that because Mr. Ibrahim was nervous and he admitted to prior firearms charges, he did whatever he did, and he was suspicious of what was in the backpack. So we have a traffic stop for illegal tint, and then we have a bunch of itinerary questions. Guys, we say it all the time, but this is why you don't answer these questions. I mean, look, hey, officer, no disrespect to you, but I'm going to remain silent, and I'm not comfortable answering any questions without counsel present. That is an invocation of your Fifth Amendment rights, and then actually shut up after that. All of the information that this trooper used to turn this situation into something that it didn't need to be actually came from the cooperation of Mr. Ibrahim. And it backfired on him, despite the fact that he was a current City of Boston employee and was probably expecting some professional courtesy, or at least allowed to do his job and go on about his way. But that didn't happen, and it ain't going to happen for you either. So keep your freaking mouth shut. Let's continue.
A few seconds later.
Hold on. Why? Yo. No. Stop, dude. Stop. You're going to make it worse.
As the chaos unfolds, you can see them struggling over the car's transmission as Ibrahim tries to put the car in drive and the trooper struggles to keep it in park.
You're going to kill somebody, dude. Okay. You're going to kill somebody.
The struggle continues. Then you can hear the trooper use his taser on Ibrahim. Not shown on the video, but in the police report, the trooper says he had to drop his taser to put the car back in park, saying, quote, Ibrahim picked up my taser and deployed the second set of probes into the lower right side of my abdomen, causing excruciating pain. Ibrahim eventually agreed to surrender and with the help of an off-duty Boston police officer was placed under arrest. Inside the car, according to the report, a .40 caliber Glock pistol modified to make it a fully automatic machine gun. Ibrahim's attorney telling us, quote, there are significant legal issues concerning the stop and why my client was pulled over, and that may impact the remainder of the case. The Wu administration is also responding tonight, saying the city placed Ibrahim on unpaid leave as it learned of the allegations. Reporting live tonight in the newsroom, Brittany Johnson, 5 Investigate.
Brittany, thank you for bringing us that.
Now, what's great about this case is that it gives us an opportunity to talk about some of the traffic stop cases that sort of lay out the constitutional parameters for when it might be appropriate for a cop to do a Bill Goldberg style WWE dive across the driver and into a vehicle. And I'll give you a hint, there aren't a lot of circumstances where this would be legal or warranted, and this ain't one of them. So we know that according to the United States Supreme Court case of Rodriguez, which is 2015, that the scope of an investigation on a traffic stop, at least at the outset, is limited to the mission of the original stop. So in this case, we have darkly tinted windows. Unless and until the officer can develop some reasonable articulable suspicion of some other crime, some other offense, then the officer cannot pivot to investigate something else. Well, what do we have in this case? Well, we have window tint. That's a violation. So had Ibrahim invoked his right to remain silent and closed his mouth, that's probably still where we'd be. Now, I'm not naive enough, and I don't expect you to be naive enough to believe that the trooper would have just accepted whatever he had to say and moved on with his life. What I am saying, though, is that the way it should have been played is not the way it was played, and that will matter more as we progress more in the analysis. The next thing that we need to consider is that the trooper noted that he detected the odor of marijuana. Okay, fine. But here's the issue. Massachusetts decriminalized possession of less than an ounce of marijuana a few years back. So if he asks Ibrahim if he's been smoking marijuana, and he says, yeah, I was earlier, but not recently, and the thing that you're smelling is coming from the ashtray, there's nothing there that would suggest that a crime is afoot. Now, again, that's not going to dispel the suspicion of the trooper because that's impossible to do, but there is a distinct difference between the odor of burnt marijuana and the odor of green marijuana. Burnt marijuana is consistent with prior use. Green marijuana may suggest that there's some more marijuana somewhere, but it varies quite a bit in the strength of the way marijuana smells based on how it's packaged, whether it's packaged. I mean, there's a lot to it, and it's not all something that could be laid at the feet of criminality, especially in a city where marijuana possession has been decriminalized. So we don't have reasonable articulable suspicion of crime or some offense in order to even pivot away from an investigation into vehicle tint. So the first thing we have to look at here is a violation of Rodriguez. Did he even have enough to pivot to a criminal wrongdoing investigation in the first place? Are we even beyond the scope of the original traffic stop just by simply asking him about the bag and all this stuff, right? So we never do find out if he goes back, runs the license to figure out whether he has warrants, any of that stuff. This all turns into a shit sandwich, all because of what Ibrahim says and does in response to the trooper's questions. So unless this trooper is going to investigate impairment, that would be like the only thing that maybe, if he suspected that Mr. Ibrahim had recently smoked, maybe he could have started an impairment investigation. But the thing is, that's not what he did. He didn't ask him to step out. He didn't ask him questions like that. He didn't ask him anything about impairment. So it's not reasonable to think that that's what he was actually doing. He was thinking that he had drugs or guns or whatever, and that's where he was going. It's obvious from the line of questioning. Now, we don't have the whole body cam, and we probably won't because they've been real selective. Because, again, their agenda is just to talk about something that doesn't matter. Importantly, though, the courts in Massachusetts have said that the odor of marijuana alone is not sufficient for probable cause to search a vehicle. And so if you don't have probable cause to search a vehicle and marijuana is decriminalized, I would argue you don't even have reasonable articulable suspicion to pivot to a criminal investigation because we don't have any evidence of a crime. I don't know how anybody makes a straight face argument that based solely on the smell of even burnt or green marijuana that you could smell that there was more than an ounce of marijuana. It's just not there. If the trooper had suspected that this backpack was a place where he had an illegal amount of marijuana, the odor alone is not enough for probable cause to search the backpack. And it's important because you see officers all the time kind of resting their hands on the sill of the window. That's fine. That's not, there is a threshold there, but it's about what the intent of the police officer is. If we're just having casual conversation and the officer's resting his hand on the threshold of the doorway, the intent is we're just having a conversation and this is what I do with my hands. When you reach inside the car, that is breaching the doorway for the purposes of either seizing or searching. And that's what's illegal and what's in violation of the Fourth Amendment. And again, in the absence of probable cause or some other exception to the warrant requirement like consent, we don't have enough here. Now, the real turning point in this scenario is the conversation about guns and prior arrests. And again, this is why you don't answer these questions. So you might say, well, James, if I say, hey, man, have you ever been arrested for guns? And you say, yeah, I have a long time ago. And then I say, well, what's in the backpack? And then you immediately pull it away after I ask you about guns. That's suspicious. Yeah, you're right. The problem is guns aren't illegal and neither are having them in your backpack. So I might just not want you up in my business, and there's nothing wrong with that. That's called denying consent when you ask to search it. You can't punish me for that. That's retaliation for invoking a Fourth Amendment right to be protected from unreasonable searches and seizures. I agree it's suspicious, but it's only suspicious that I'll have something in there that I don't want you to know about. It doesn't necessarily mean that the thing in there is illegal. And even if it does mean that the thing in there might be illegal, it's still not probable cause, and it's still not an invitation for you to jump across the freaking window. You got to tell me somewhere in Fourth Amendment jurisprudence where it says that simply because you're suspicious of something, you can dive into my window and investigate anything you want to investigate. That part of the Constitution, I mean, I have no faith that it's not ultimately going to be written, but it hasn't been written yet. And I think what's even more frustrating about this particular stop is that it is an absolutely perfect example of how officer safety is nothing but a buzzword or buzz phrase that they use to justify bad conduct of the police, and evidence that cops have no actual understanding of Pennsylvania versus Mims. This case, this exact scenario is what the opinion in Mims was actually written in contemplation of. If cops were truly being trained to understand Mims and to adhere to sound principles of officer safety, here is what would have happened in this case. As soon as the trooper started asking him questions about the gun conviction and the backpack, and he said, no, you can't search it, and grabbed it, the officer should have stepped back, made a lawful order for the driver to show his hands and step out of the vehicle. That's what Mims is for. You're supposed to use Mims to separate the driver from the vehicle under the idea that it's safer to be able to see him and everything he can touch. Position him in a place that can be better controlled and where the officer can observe his hands and observe his movements. And it's obvious that Mr. Ibrahim here knew that he had stepped in some shit, and I think it's pretty likely that he would have fled had the officer done that. But if that had happened, you know who he is, you know what his plate number is, you know where he works, you go get a warrant and you arrest him, and that's it, and everybody goes home. Instead, the principles of officer safety are completely ignored, and the constitutional protections under the Fourth Amendment are completely ignored. In fact, I would argue pissed upon. And in order to secure that backpack, one of three things needs to happen, and none of them happened. Number one, the driver would need to give consent to the search when the trooper asked. Clearly, that didn't happen. A second option would have been that An officer observing from a lawful vantage point, i.e. outside the car, observes something in plain view, and it is immediately apparent that what he observes is illegal. If he has a lawful pathway to access that thing, he can secure it for evidence without a warrant. And the third option would be that the officer needs to get a search warrant based on probable cause. But remember, the primary case that shaped the plain view doctrine in this country is called Arizona versus Hicks. And just sort of like the quick and dirty details of the facts in that case, officers were lawfully present in a home where a shooting had occurred. They noticed during the course of their search that some audio equipment that they believed to be stolen was present. And one of the officers picked up the audio equipment to look for identifying numbers on it. Justice Scalia, who was very deferential to law enforcement, wrote the opinion in that case and said, no, you can't pick something up, manipulate it, turn it over, or look for identifying numbers. That is a search. And you have to have an exception to the warrant requirement or probable cause or consent before you search, not afterwards. And otherwise, you violated the Fourth Amendment. Well, what do we have in this case? Marijuana is not illegal in Massachusetts. Guns are not illegal in Massachusetts. Nothing has happened to lead us to believe that a crime has been committed other than furtive movements, which alone, again, the courts have held are not enough. Nothing here meets the plain view doctrine. If you can't pick up a piece of audio equipment to inspect it for a serial number on the scene of a shooting without that being an unlawful search, you can't dive through the fucking window of a car and grab a backpack and call a person refusing consent the grounds for exigency. And even if the gun was in plain view, the only way a Glock can be a fully automatic gun is a couple different ways. It's either a Glock Model 18, which was not sold in the United States, and you'd still have to have picked that up or seen Model 18 in plain view, and then the trooper would still have to know that Model 18 was designed to be an automatic gun. It's not there. Or the other option is it could have an auto sear or some other device installed that would convert its ability to fire semi-automatic rounds into fully automatic rounds. And the gun was not in plain view. Even if the gun was in plain view, you would have to field strip the gun and observe its internal parts in order to know that this scary Glock machine gun existed. None of the things that would justify this search are present in this situation. So regardless of what the media would have us believe about scary machine guns, no one was in danger here until this trooper put everybody on scene in danger, as well as everybody that was anywhere close to this. Even though they searched the car illegally, after they searched the car illegally, and they found a gun that had been modified, that is nothing more than an unconstitutional search following a hunch that was later proven to be true through unlawful means. Literally, none of the evidence would be viable in this case as far as a gun or dope. Hell, they could have found a human head in that backpack and we'd have a murderer walking free because all of the evidence secured in the process of that search is tainted and will be suppressed as fruit of the poisonous tree. And what about this officer safety problem? This dipshit trooper threw himself and all of the tools on his bat belt all of the way across the driver's side seat and the driver, to the extent that the person who had the best access to these weapons was the driver and not the trooper. He claims in his report that the driver kept putting the car in gear and trying to drive away. If I'm his lawyer, I'm making the argument that there is no way to prove that the trooper's body did not itself put that car into gear. And then on top of that, this idiot loses control of his taser. Actually, he reports that he willfully gave up control of his taser in order to put the car in gear. And then in his statement, he says that Ibrahim deployed the taser into his abdomen and shocked him. But guys, this entire incident is some cowboy bullshit that gets people killed over nothing. Had this driver actually intended the trooper harm, the trooper would be dead. I've been shot with the darts of a taser. It completely incapacitates you. The driver could have easily killed him if the case was that he wanted to do it. Now, I do believe we're probably going to see a conviction in this case, and I know that's probably going to surprise you given what I've said, but it won't be for guns or for dope. Massachusetts did away with any common law allowance for people to use force to resist an unlawful arrest. or unlawful conduct by the police. So if the prosecution can successfully prove beyond a reasonable doubt that the driver intentionally gained access to that taser and used it against the trooper, there will be no self-defense privilege that will save him from conviction from assault on the law enforcement officer. If he did in fact do that, and they can prove it, he's probably going to be convicted. Had that not happened, he would probably walk with absolutely no conviction in this case, based on what I know about the evidence right now. And so if there will be a conviction, it will be based on that. In closing, this is a perfect example of law enforcement using phrases or buzzwords to justify their bad deeds and then acting in ways that makes it obvious that they are not operating on sound legal principles. What this trooper did was not only illegal, but it was unjustifiable and it was reckless. If this exact same scenario played out the same way 9 more times, I would predict that 7 or 8 of those 9 times, someone would be dead. And half of those times, it would be the trooper himself. He endangered himself, he endangered the driver, and he endangered the public so that he could feel like a hero. And it was stupid, and he should be immediately fired as a result of it. If he gets away with this without consequence, mark my words, this trooper will eventually do something that leads to the loss of human life. And it probably won't be that far down the line. As a final note, I want to thank attorney Peter Morano, who represents Mr. Ibrahim on these criminal charges. I reached out to him. I asked him if he'd be willing to sit down with me and talk about this case. He was more than willing to do it, and we connected a little bit over the telephone, but we just didn't have the ability to make the schedules line up. So hopefully I'll be able to get an update or speak with him at some point on the record in the future about what's going on with this case. But it wasn't that he didn't want to be involved or that I didn't want to talk to him. It just happened to be that we couldn't work it out. Anyway, I just saw this case and it was wacky, and I knew that this was something that was something off about it, and I wanted to bring it to your attention. I invite you to check us out on all of our other platforms. There'll be a QR code here on the screen. All you got to do is pause the video, or if you're real fast, you can just pull out your phone and scan it, but you weren't expecting me to say that. So even with the Southern drawl, it probably wasn't slow enough for you to get your phone out. But pause the video, scan it with your phone. It will take you through the portal of the interwebs to the respective platforms so that you can sign up and support the Southern Draw Law channel on other platforms. If you come to the Substack community, you can join on a paid tier if you like, but that's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for. If you don't want to follow us to other platforms, but you would like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.